I am recording Eric Segall today. We heard arguments at the Supreme Court, and we actually heard them. They were live on audio. We talked about this technological advancement, we could argue, last week. But today's hearing was about something very important, the president's financial records before he was president. Take it away, Eric.
Okay, so these two cases, when they say make a federal case out of something, they usually mean that you've blown it up out of proportion. In one respect, these cases are incredibly important, obviously. In another respect, though, they shouldn't have drawn the attention of the Supreme Court like they did. The District Attorney of New York thinks state and federal crimes were possibly committed. He issued a subpoena to a third party for Trump's financial records before he became president. The House of Representatives of the United States Congress wants those same records to study the issue of what we should require presidents to disclose when they run for office or take office. Those are both legitimate law enforcement, law execution functions. Donald Trump was not a defendant in either of those two cases.
The third party.
Sorry?
The third party is?
Yes. Now, he swooped in. He said, let's do this. He swooped in and said, don't let the third party disclose those documents. Here's the thing, Pete. We have two major cases on point. They're not exactly the same, but they're very similar. Richard Nixon secretly recorded his top officials, Secretary of Defense, Secretary of State, Attorney General, in the Oval Office. And when those materials became relevant to a criminal investigation, the Supreme Court said you have to give them up. He said, I'm the president. No, I don't. Supreme Court said, yes, you do. Now, if there's state secrets, if there's, classified information, you got to get rid of those. But the non-state secrets, non-classified information, you have to give those up. That's one case. That case applies here to some degree, except this case is even easier because that case involved official documents.
Right, when he was president.
When he was president. Well, official tape recordings, excuse me. Second case, which is really on point. Paula Jones claims that Bill Clinton, when she refused to give him a blowjob, sorry, but that's what she claims, or claimed, when she refused to give him a blowjob, he retaliated against her in all kinds of employment ways when he was governor of Arkansas. She then filed a civil lawsuit against him. His argument was very clear. I'm not saying she can't sue me. I'm saying she can't sue me now.
And that she has to blow me. I mean, I can't get over that. The idea that if it's true, I mean, did Bill Clinton really retaliate because a woman wouldn't perform a sexual act on him?
While he was governor of Arkansas, probably. Whew. Yeah. Well, that wouldn't be out of character with Bill Clinton.
Okay. All right. I mean, okay.
So I thought he should resign at the time when this all came out. But not the Paula Jones thing, the Monica Lewinsky thing. But anyway, it's very clear to understand precisely what Bill Clinton's argument was. It wasn't you can't sue me ever. It was you can't sue me while I'm president. Because if I have to go to depositions and answer interrogatories, and it's going to take up too much of my time. By a unanimous vote, Justice Breyer wrote a separate opinion, but agreeing with the vote. 9-0. No, President Clinton, you must defend this lawsuit while you're president because the events complained of happened before you were president. If he had been involved in a drunk driving accident a month before his presidency, it'd be the same thing. And they'd say, no, you have no immunity here. You have no executive privilege here. This all happened before you became president.
It's a matter of there being question of your privilege or immunity in terms of the protection you get for being the president of the United States. But if you're president and there's an investigation about an allegation or a crime that you committed allegedly before you became president, that's fair game.
And Pete, let me explain very precisely why the reason for that is, because it's directly relevant to this case. The president cannot be sued ever in a civil action for actions he takes while he's president. That's a controversial decision, but it is a decision of the Supreme Court. Okay. No matter what he does, he can't be sued. The rationale was we don't want presidents to worry about being sued when they make decisions that affect the whole country. We don't want him to worry about that. Do what's best for everybody. Don't worry about lawsuits. So we're going to put you above the law, which that rule does. It puts the president above the law. But it's worth it according to the majority. Okay. But in this case, No decision by Trump is being questioned while he was president. No document he produced while president is being questioned. So the lower courts had a very easy time with this. They were unanimous in both cases. All courts, four decisions, not unanimous, four decisions. Of course, the DA of New York and the House of Representatives gets to see these pre-presidential documents because we live in a country of laws. And
documents which are financial records that are being held by a third party. In this case, I think it's Deutsche Bank or a bank.
Several third parties, Deutsche Bank and his accounting firm and a couple of, yeah.
Okay.
Yeah. But now, what the justices were a little bit concerned about today, and I get this, is what happens if 250 district attorneys issue subpoenas against the president? What happens if the House of Representatives issues 27 subpoenas, 50 subpoenas against the president and hound him and harass them? What would we do then? That's a legitimate question. And the answer from the lawyers was the correct answer, the lawyers for New York and for the House of Representatives. And by the way, I should say the lawyer for the House of Representatives, a man named Doug Letter, I worked with for 4 years at the Department of Justice. He's an excellent, excellent man. He is neither, as far as I know, he's neither Republican nor Democrat. I mean, he's working for the Democratic House now, but he's just a good guy.
And how did he do? Because how was his performance? I only asked because Dan Abrams was critical of it.
Yeah, a lot of people don't like his. So, by the way, he's argued like 1,000 appellate cases, not Supreme Court cases, but appellate cases. Okay. He was head of the appellate division for the Department of Justice for 30 years. His style, Pete, is very kind of modest and humble. And when someone asks a good question, I like your kid in the background. When
my daughter just walked by. Yeah. Go ahead.
When somebody asks a good question, he says to the justice, "That's a good question, Your Honor." He's ruthlessly honest. Okay. I like that in litigant. Anyway, what he said was, well, if that happens, if the president is truly harassed by 200 different district attorneys, we'll worry about that then. But that's not today's case. And Your Honors, you shouldn't, if that happens, and the Supreme Court has even said, the name of the case is going to elude me, but the Supreme Court has said, the possible abuse of a power is not an argument against its existence. And that's always true. So here, the House of Representatives and the District Attorney of New York are just doing their jobs. Now, is there a political motivation here? Maybe. I'm not stupid.
I mean, listen, I just a bit of commentary, just very, very briefly. Mayors and governors and presidents, there should be a law. There isn't, I get it, but there should be a law that makes them have to be transparent with their investment, all their financial records, all their taxes, everything has to be on the table. If you're a public servant, that doesn't mean the case if we're private citizens, but if you are a public servant, mayor, governor, anybody, president, all of your financial records have to be on the table. And in this case, they're saying for a number of reasons, the president of the United States, we have many reasons to believe this or that. We need to be able to see his financial records. And if he's got nothing to hide, fine.
Well, it's not just him, Pete. So an overlooked part of this case, although the attorney for the district attorney really tried to press this, was that this case involves Trump and others who may have committed crimes. Now, the statute of limitations for these crimes might be able to be told for the president. I'm not sure about that, but maybe. But as the district attorney said, there's no way to told the statute of limitations for these other alleged wrongdoers who these documents might, in fact, show did wrong things. So all the DA is doing is his normal law enforcement functions, and he should be allowed to do that. This case would be very different if these cases involved official presidential documents. But here's the thing. The Watergate case already tells us, even if they involved official presidential documents, they'd have to be turned over with the proviso. And let's be really on the ground here. If the president receives, or the president's lawyers receive 100 interrogatories, well, first of all, strike that. The president doesn't have to do anything here. These subpoenas are to the banks and his investment firm, his tax firm. So he does no more work whether these subpoenas are granted or not. There is no reason why the president of the United States' private financial papers, if relevant to a crime, should not be able to be received by people investigating that. Or the Congress, who is trying to figure out what do we do in the future about presidents who refuse to disclose their tax returns.
What is that thing that keeps going off? Are you getting emails? I keep hearing a bleep, a bloop, a blop.
Yes, I'm going to get rid of that right now.
Very in demand.
Lynn was supposed – wait a minute. I'm blaming my wife for this. Sorry. She was supposed to fix that, but she didn't.
That's fine. I just don't want to hear anymore, and I have a few more questions, including what else you heard from the argument. What you are
so here's one interesting thing that
conclusions
happened.
And whether or not Kavanaugh and Gorsuch had decided this case the moment they were appointed.
Well, Kavanaugh, yes, he's a toad. He was a toad today. Gorsuch, there's only one of two possibilities about Justice Gorsuch's performance today, and I sent this out on Twitter, and no one disagreed, and many people agreed. Only one of two possibilities. There's three, I guess. Either he's going to rule for Trump, or he wants the world to think he's going to rule for Trump, or today he was going to rule for Trump, but he might change his mind, and that's fair. Every question Gorsuch asked, almost every question he asked, suggested he was going to rule against Donald Trump, which is interesting. Justice Roberts was fair, asked questions on both sides. Thomas was a toad, as usual. Thomas talked, but was bad. Sotomayor was the smartest person today. And let me tell you why real quick.
Okay.
She focused more than anybody else on the distinction. And it's an important one, Pete. I worked for the President of the United States. The Department of Justice. I have you know what I did for them? Mostly is I handled document requests and said no. I am very sympathetic to the idea that the executive, I worked on Lockerbie, I worked on Iran-Contra, all involving documents. I am sympathetic to the idea that separation of powers requires the executive branch to have an autonomy and a separateness from Congress. That is important. But with Sotomayor and for the president to have his own unique place. But what Sotomayor said over and over today was this is not a case where the president is claiming executive privilege, which I claimed many times. This is not a case, on behalf of the president, this is not a case where the president is claiming state secrets, classified information, any of that stuff. This is a case involving his personal documents that predated his presidency. And she was like, why is this hard?
That are extremely relevant to ongoing investigations.
Yes, and her tone was exactly like your tone. What's the big deal here? Now, let me tell you what other people said, smart people that I respect. Clinton versus Jones should decide this case.
Yeah, one would think. And didn't Ruth Bader Ginsburg ask that right out front? How is that not the precedent, as we described earlier? How is it not? What is their defense?
I'm going to tell you. This won't surprise you. If the Supreme Court were a court of law, and if its justices were judges, this would be an easy case.
Right.
They are not a court of law, and they're not judges. So what is this really going to come down to? I think it's going to come down to, we know how Breyer was weird today. He asked questions that suggested he was having a hard time with this. But I think what it's going to come down to is, do Roberts and Gorsuch want to protect the president, or do they want to follow the rule of law? And let me tell you, Pete, in every case the Roberts court has ever decided, back to 2006, even when Kennedy was the swing vote from 2006 to 2018, Senator Whitehouse has made this argument in print and in front of the Supreme Court and in this case. In a separate case. Every time the Republican Party's interests are at stake, Roberts has voted for the Republican Party. Now, someone may say, wait a minute, Obamacare. And my response to that is, Obamacare was not a political case like this. It didn't involve elections or voters or process, things like that. And by the way, I think Roberts did vote for Republicans in the Obamacare case. That's a longer argument. But leaving that aside, forget Obamacare. In every other case involving Republican Party interests, he's voted for the Republican Party. Is he going to stop now? We'll see.
Well, this doesn't seem to be a difficult thing, not a complex one. Lower courts decided unanimously on this. The President of the United States.
Oh, hold on. There may have been a dissenting judge on the Court of Appeals panels, but the results were unanimous. Yes.
The President of the United States did some very shady things. We all know that before he was president. We need to know what he is tied up in. We need to know where the money came from, where his investments are. And, of course, the issue of his taxes, the fact that he refuses to be transparent about his taxes raises plenty of questions in the public's mind. This isn't partisan. I've said this over and over. This is not liberal. This is not conservative. Mayor, governor, president. We have to know. There are very few arguments that I can even imagine where we wouldn't need to know where your money is invested. You are taking taxpayer money and deciding what happens with it. What if you're invested in hydroxychloroquine? What if you're invested in black paint for fences? What if you're invested in McDonald's that you're serving to the Super Bowl winner?
Hold on. Or what if, while governor of Arkansas, you took somebody's employment and screwed it up because they wouldn't give you a blowjob? I think the American people have a right to know about that happened before you were while you're president, which is exactly what the Supreme Court said.
Whatever happened before you were president, especially, it's a different argument as to the actions that you take while you are president. Yes,
and the court has said that. The court has said the president has absolute immunity while he's president from civil suit. But in the Nixon case, the court did say even the most confidential communications between the president and his top advisors need to be given to a judge for inspection if they're relevant to a criminal case. Now, in fairness, the court in that case did say, we're not opining about congressional subpoenas and we're not opining about state subpoenas. So that's fair. But the rationale of that case would certainly apply. But it doesn't matter because these aren't presidential documents. These are Trump documents. And those are different things. Pete, hold on 1 second. If Monica Lewinsky had sued Clinton for like employment discrimination or assault or anything, maybe not assault, but any kind of official demotion while he was president because she refused his sexual advance, she couldn't do it. Absolute immunity. And the reason for that is we say when the president is in office, everything he does is part of his official duties, and we can't have him worried about lawsuits. But this case involves the man, not the president.
That being said, there could be congressional oversight for anything that the president does while in office by the House Oversight Committee.
There should be, sure. Unless it's unduly harassing. And the lawyers today conceded, the lawyers for Congress and for the state and for New York conceded, well, the judges here, the trial court judges, the original judges, made a finding of no harassment. If they had made a finding of harassment, this would be a different case. Because Pete, you and I can object to subpoenas if we say you're only doing this to harass us and for no legitimate law enforcement purpose.
Is that why you objected to my subpoena?
Exactly. It's why I'm not in jail today.
Well, this interview is over.
I'm sorry we couldn't do it live.
Well, I'm going to post as much of it as I can. I'm going to press end. Thank you very much, Eric Segall, at eSpinSegall on Twitter. Follow him for all of the best con law analysis. Thank you.
Thanks, Pete.
Listen to Stand Up with Pete Dominick anywhere you get your podcasts and subscribe to youtube.com/standupwithpete.